All right, I think we can start the session, right? Okay, good morning, everyone. Good afternoon, good evening, good day. My time zoning is really out of place, but I'd like to welcome everyone to the second day of the GNHRE 2021 Summer Winter School. Now, today's session is going to be dealing with environmental rule of law and human rights. So trying to find an intersection between environmental rule of law on the one hand and human rights on the other. Leading the discussion today, we have two experts, people that are working in the specific field. We have Dr. Suyang Wang, and we also have Professor Tumai Murombo. But before I introduce the speakers for the day, I would like to just lay down a few ground rules. Please note that the session is being recorded, so if you do not want to appear in the video, just ensure that you turn off your video feed off, right? Let's try and make sure that our mics are kept off at all times so that we don't have any background noises disturbing the speakers. Any questions, we advise that you post them on the chat box, and we'll be sure to post them to the speakers. We'll see along the way if we have the capacity and time to have direct questions from the speakers themselves. At this point, I'd like to ask Ms. Angela Kariuki to just come in and say a word on the platforms that we'll be using today.
Thanks very much, Bruce, and good morning, good afternoon to everybody. So as Bruce said, today we're using this WebEx platform. Everyone's mics are muted, but if there is time during the discussion session, then we will invite you to unmute yourself and raise your question live. We'll be making use of two tools during this class. The first one is the polls, which will appear in the WebEx platform itself. And then the second one is a tool called Jamboard. I'm sure many are familiar with it. It works through Google. I will post instructions in the chat as well. Otherwise, I think everything is quite straightforward. If you have any technical problems, just also send a message in the chat and we'll be able to assist you with that. Thank you, Bruce.
Thank you so much, Angela. All right, so the big part, I'm going to introduce the speakers for the day. So as I said, we have two of them. Our first speaker for today would be Dr. Suyang Wang, who is currently and presently a legal officer with the United Nations Environmental Program, that's UNEP, and she works on the advancement and implementation of environmental rule of law and environmental rights. So she's really speaking on stuff that she handles on a daily basis. Now, prior to joining UNEP, she worked with the United Nations Office of the High Commissioner for Human Rights, and she was specifically focusing on economic, social, and environmental issues. She's also worked with the National Human Rights Commission of Korea and the Ministry of Gender Equality in Korea as well. She holds a PhD in international relations with a specific focus on states' compliance with international law and norms. For her presentation today, as I say, she's speaking on stuff she presently works on. She will speak on the meaning and development of environmental rule of law, as some would call it EROL, and the relationship between EROL and human rights. She'll also touch on issues that have to do with environmental rule of law and how UNEP handles EROL and specifically environmental rights. The second speaker for today would be Professor Tumai Murombo, whose specific focus would be on the practical aspects of environmental rule of law through a discussion of civic engagement and environmental rule of law. So at the start, we're going to have more of a theoretical, broad, generalized discussion by Dr. Suyang, and then Professor Tumai Murombo will get into the specificities of how it might work in practice, EROL that is. So Professor Tumai Murombo has a PhD from WITS, that's University of the Witwatersrand here in South Africa. He has 2 LLMs, Master of Laws from University of Cape Town in South Africa and Pace University in the United States. He also has an LLB degree from the University of Zimbabwe. Presently, he is a professor at the WITS University and he's a former director of the Mandela Institute. He's an admitted attorney, practiced and licensed to practice law in Zimbabwe, and he's an expert in environmental law, energy law, climate change, sustainability, extractives in the environment, water law, and governance, among other issues. He is an NRF-rated researcher. NRF, that's the National Research Foundation of South Africa, where experts are rated on the basis of their expertise. So he's one of those, and he has researched, advised governments, and civil society as well, organizations on matters that are related to his expertise. Prof. Morombo co-founded and is board chair of the Zimbabwe Environmental Law Association. He presently sits on the editorial board of the Journal of African Law, and he's a member of the Water Tribunal of South Africa, the Environmental Law Association of South Africa, and the IUCN Academy World Commission on Environmental Law, as well as its Environmental Law Academy and Working Group on Climate Change. So we are in the midst of experts here, and we are sure to enjoy the presentations that we'll give today. One more thing I did not mention at the beginning. So after the presentations are done, we will just have a 5-minute coffee break before we turn to the questions. Without further ado, Dr. Su-Young Wang, please bless us with your presentation.
Thank you. Thank you so much, everyone, and thank you for introducing us. So good morning, good afternoon, good evening, wherever you are, and I really appreciate you taking the time to be here with us today. So as Bruce mentioned, I'll be speaking mostly on the environmental rule of law and the work we are doing, and also the relation of EROL to human rights. May I share my screen? So I hope that you can see the screen. Okay.
Yes.
So thank you. So, oh, sorry. Could we do the poll before we proceed with the presentation? There are like 5 very simple questions, and that's just to initiate the conversation or the presentation.
Yes, Su-Young, we can do that. If you can just stop sharing your screen for a second, because I think it has something, it blocks the poll. Okay, it hasn't changed. Okay, Su-Young, I'm going to have to ask you to go ahead, and I'm going to put the poll up as soon as I can. Sorry about that, but it's frozen again.
Su-Young, we cannot hear you. You're muted.
Okay, so thank you, Angela, and thank you, Bruce. So we'll proceed with the presentation first. Okay, so I suppose that you can see my screen. Okay, yes. So one of the poll questions, we actually had it like, take a wild guess when this environmental rule of law was first introduced. So I'm very sorry you're missing your chance to be right. And so I'm gonna just have to reveal the answer. So I think a lot of you, like some of you may be familiar with this concept of environmental rule of law, and some of you are not. But relatively, this is a very, very new concept. So it was first introduced in 2013 through the Government Council Decision 27/9. So it was first it emerged as a concept in the internationally negotiated document first in 2013, and excuse. So since then, the UNEP is given a mandate to work on the environmental rule of law, to advance it and also implement it. So as you can see through the Montevideo 5 program that we are working on environmental rule of law and other issues as well. So what is environmental rule of law? So I'm sure like a lot of you are very familiar with the rule of law. So simply speaking, so like the components of rule of law, not limited to only these 3, accountability and fundamental rights, and also inclusive development and implementation. So all of these components of a rule of law, applying that in the environmental context is that that's how we understand, in like simple terms, that's how we understand environmental rule of law. So rule of law in the environmental context, and the components of environmental rule of law, as you can imagine, so there are 4 components of it. So one is laws and institutions. And the fundamental problem with the laws and institutions, you can have really great laws and institutions, but it's not always they're implemented, or it's not done in the right way that benefit people and with participation of the people. So that's one big component of environmental rule of law, but there are also others, such as civic engagement, that Tumai will be speaking in more detail later on. So, so the laws and institutions, it has to be participated by civil society and the individuals and groups that are affected by it in the decision making, but also in and also making the outcome efficient and rights. Last night I was choosing the icon for rights, so I'll be the good icon for rights, and then I typed in celebration. So this is the icon that I got. You might find it a little bit funny, but fundamentally, I think human rights is about enjoyment. So it's about enjoying your human rights. So environmental rule of law and your full enjoyment of human rights, such as right to water, life, health, and adequate housing, and all the other, all human rights components is also embedded in the concept of environmental rule of law. But what happens? You have the law, and you have the engagement, and you have the enjoyment of human rights. But when it's violated, when the environmental laws and are not implemented and your rights are violated, there also has to be a strong component of justice. So you can claim your right, and you can also have access to justice and have the remedies when there's a violation. So those are the largely 4 components of environmental rule of law. And what is a difference between, what makes environmental rule of law distinctive from the conventional rule of law is that there are many components into it, and there are many key aspects of it. One is it really concerns about human health. So rule of law is more on what's happening right now, and also about the laws being implemented and so on. But environmental rule of law is very much concerned and has an emphasis on human health, and also requires multiple levels of governance. So it's not just environment Ministry of Justice, and it has a lot to, but it involves multiple levels, such as at the federal, or it depends on the government structure, the Ministry of Environment, but also Ministry of Justice, because we're talking about justice, and Ministry of Green Affairs, or maybe sometimes on the national human rights institutions. So it really requires many multiple levels of the governance in the implementation of environmental rule of law. And also it has a different time scale. So when we discuss rule of law, that is about actually now, usually, but environmental rule of law, it has an everlasting impact because the environmental degradation and also the future impacts. So it has a bit of larger time scale into it, and also has a lot to do with the natural resource dynamics. So it really depends on the country's context and the resource management, and also resource scarcity. So it has it really depends on the natural resource dynamics, and a lot of it is quite uncertain in many ways, because the rule of law can be very implemented in a more simpler way. But since environmental rule of law, the environmental conditions and also the environmental crisis that we're experiencing, they're quite unpredictable in many ways. And so it really has that component of unpredictability. For example, we never knew that we'll be experiencing the pandemic for almost 2 years. So that's a few distinctive characteristics of the environmental rule of law, how they're different from the rule of law. And what is the benefit of having the environmental rule of law? This one is that without the rule of law, is the enforcement of legal rights and obligations can be discretionary and subjective and unpredictable. So with the participation of civic engagement with civil society, and also the rights being implemented and fully embedded in environmental rule of law, we make sure that the environmental policies and laws, they're implemented not arbitrarily, but coherently, and also consistently. And environmental rule of law support the sustainable economic and social development. So it has a lot to do with the natural resource management. So it's really it's making sure that the decisions and also the outcomes of the policies are actually supporting the economic and social development, and protects human health. and public health, and the peace and security. You will see many conflicts that are caused by the natural resource management, and also at the international, also national level. The environmental rule of law, we make sure it's to put the rule of law in the environmental context and make sure that the peace and security is promoted and sustained, and also enhances social cohesion by the participation and also working the partnership between like multiple various stakeholders, and protects fundamental human rights, which I'll be talking a little bit more later, and increase trust in the government and solidify its legitimacy, because we see a lot of policies and laws that doesn't really have a lot of legitimacy. But with the environmental rule of law, the participation, and with a strong mechanism for implementation, we support the environmental rule of law supports the policies and laws and institutions are more legitimate and also more supported by the general public. So what is a UNEP doing? I can just, a lot of things. So I'll just talk about two major, two flagship reports of the UNEP in the environmental rule of law. So since 2013, Governing Council decision, so UNEP published the first global report on environmental rule of law in 2019, as you can see on the left side. And then we plan to have biannual publication and updates on the environmental rule of law, assessing global trends on the environmental rule of law. And we have 2021 report coming up later this year. And it will have a big components on, so we'll capture the global trends, what's happened in the last 2 years. So I think, as you can imagine, a lot of things happen, but COVID-19 is a big thing that happened. So it will be fully integrated in the report. So we'll be capturing like what happened in terms of the laws and institutions and the civic engagement and human rights and the justice and good practices. That's another approach that we are taking, because we hear a lot of bad stories, but also there are a lot of good things happening. So we want to promote the good practices of what's happening by all the stakeholders, so government and the civil society organizations and some others as well. So, and there are two purposes. One is to promote good practices, to tell people this is good things happening. But second of all, because we hear a lot of government saying that they understand the law, they understand the policy, they understand the international standards, everything, but they are not just sure how they can apply it in practice. And sharing these good practices, like learning from each other's experience, we learned that that is actually really, that helps states to implement environmental rule of law and their policies. So that's the reasons why we're promoting good practices. And we're also going to have a data-informed analysis in the report. So we laid out like 23 indicators. That's quite a lot. So, for instance, does your country recognize the right to healthy environment? So the questions will be the answers will be binary, so yes or no. But it is to so we have indicators for all 4 components of environmental rule of law, and this is to capture like how countries are making where we are. Like, so the data will tell us, the numbers will tell us where we are and also where we'll be heading. So we're hoping that we'll be continuing like every 2 years on these indicators to actually be able to see quantitatively like where we're going and what is the gap that we need to fill in. And we also we'll also have recommendations for states and all the stakeholders in how we can advance environmental rule of law and implement it better. So that is coming later this year. And environmental rule of law and human rights. So as Bruce mentioned in the beginning, I worked with the SHRE until last year for quite some time. And there I mainly worked on environmental and human rights issues with the special rapporteur on human rights and the environment. And environmental rule of law is a really big component. Human rights is a huge, it really has to, is embedded in the environmental rule of law. So without the human rights, there's really not full implementation of environmental rule of law. So it's the human rights is fundamental to environmental rule of law. and it's also interlinked to other environmental rule of law components. So human rights is not separate concept or the separate framework. It's also linked to justice, because human rights talk about the right to access to remedies and also right to participate. So it's also linked to other components such as civic study and the justice and the laws and institutions. And we're not only picking and we're not going to only pick and choose some human rights that is related to some human rights only, but when we talk about human rights and environmental rule of law, we're talking about actually all human rights that is relevant for the environment. So it's not just to say the procedural ones. So procedural rights, I think Tumai will be covering that in more in depth, but it also covers the enjoyment of your right to water and all the substantive rights, the right to life and all the other rights. And advancing human rights is actually helping advancing environmental rule of law, because they're linked. And what we've seen in the environment and human rights in the past few years is actually there's a lot of convergence in this discussion. And see the first photo on the top right, you see on left, you see the High Commissioner for Human Rights, Michelle Bachelet, and on the right that you see Inga Anderson, Executive Director of UNEP. So they signed the MOU in 2019 to commit their cooperation on the human rights and the environmental area. And also see the photos like from UNEA, and the other photo that you see is the Human Rights Council one. And there's a lot of like talks and also cooperation going on between these two once separated intergovernmental bodies, UNEA and the Human Rights Council. So there's a lot of convergence in this area going, because we just cannot ignore the interdependence of the two. And so today, I think, so like this whole session, this summer school is about human rights and environment. So I'm sure like a lot of things are covered. So I looked at the other syllabuses. So I wanted to focus on things that may not be covered in the other sessions. So what I'm going to do today is to talk more about what in the developing area on environmental rule of law and human rights. Is one of it is the right to a healthy environment. So some of you may be very familiar with this, and so you can see it first appeared in 1972 in the Stockholm Declaration, which also created the UNEP. They first appeared that every person has a right to live in a healthy environment and have a health. And have the right to health. So it first appears in the in 1972, but since then there was no like globally recognized negotiated document that actually recognizes the right to healthy environment. But at the national level, 80% of the UN member states, which is about like 196 member states, they recognize a right in their constitutional national legislation or through the ratification of regional conventions such as AUS Convention and the Escazú Agreement. And why is this important is that, sorry, I think my screen is not being shared anymore. Should I continue?
Is there any way you can bring it back? If not, you can simply continue.
Okay.
Yeah, I think you can try and bring it back now.
Okay. Excuse me. Yeah, sorry. So it really serves like what we have, the national implementation of a right to healthy environment really helped to reinforce the implementation and of the environmental law, and also like we found that helped have better like environmental outcome and also the enjoyment of human rights. So there's a lot of benefit into that. And we are also so like UNEP is really hugely focusing on the right to healthy environment at the global level, the recognition of the right at the global level, because even though it's ratified or recognized by the 80% of the member states or the UN member states, is the recognition varies, because sometimes it's at the constitutional level, sometimes it's at the low level of the law or regulations, or it's sometimes this principle. So we see the value of the right to a healthy environment, and also in the relation to the implementation advancement of the environmental rule of law. So we're working to facilitate the global recognition of the right to a healthy environment. And so here, like as my last slide, and just those are the sort of like questions that come up often on the global recognition of the right to healthy environment. So I'll try to answer some of that, but also like I would like you to also have think about these questions, because there's no right answer to that. So first, where do we stand? Here I actually have an answer to this. So where do we stand with the global recognition of the right to healthy environment? So states are increasingly moving towards having a resolution at the Human Rights Council. So right now we've last March, this March, so March 2021. So we had about we've seen the joint statement of 69 states signing up to express their interest to move forward for the global recognition of the right to healthy environment through a resolution at the Human Rights Council. And also that was supported by over 1,000 like civil society organizations globally, pledging, calling for UN to recognize the right and adopt a resolution on this right. And also we had 15 UN agencies, UN entities, including UNEP, supporting states and states to recognize the right through a resolution. And what difference could global recognition of the right to healthy environment make? So there are a lot, and one is the global recognition. So it's a universal enjoyment of the right to healthy environment. So 80%, it seems a lot of states are actually recognize it, but still we have 20% that have not recognized. So we not like 20% of the countries and people living there, they do not have a legal right to a healthy environment, so to speak. So it will make sure that everyone and everywhere will be able to enjoy the right to healthy environment. And also two is the coordinated and consistent implementation of the right to healthy environment. Once this recognized at the right to at the global level, because currently we're experiencing a lot of different levels of implementation. So for instance, some countries have it in their constitution, but they will say it's not judiciable in many cases. So they say when you actually claim the right, and the court will send it back and say this is a principle. So you cannot actually claim the right. So we've seen, and some countries they allow it. So that we see a lot of variations. We'll make the global recognition will help to make sure that the implementation is done universally. And will it create additional human rights and environmental obligations? And yes and no, but yes. No, I think it will be more no. Like no, let me start with the no, because all these components of the right to healthy environment, it is actually based on the existing human rights obligations, human rights and environmental obligations. So it's not to create another new set of obligations, but it will be reinforcing them, and reinforcing them in a coordinated and universal manner. And why do we need a right to recognize at the global level when the right is already recognized by a majority of the countries? I think I covered this, that because it's no, we don't have everybody covered, and also the implementation varies. And what would the global recognition of the right to healthy environment look like, or what format would they take? So currently there has been a lot of discussions, but currently the states are moving to a resolution type of recognition. So they are considering to have a resolution on the right to healthy environment at the Human Rights Council and or the UN General Assembly. So I'm happy to also discuss this with you later, and I will stop here my presentation, and thank you everybody for listening. Thank you.
Okay, thank you. Thank you so much. Thank you so much for a wonderful presentation. I guess the one big takeaway from this is that for environmental rule of law to work, then all levels of government must be up to the task and they must be well informed about the necessities of advancing environmental protection through the concept of the rule of law. But before I call upon Prof. Tumai Murombo to speak on the practical aspects of it, just one question for you, Sue, and I'll try and play devil's advocate here. So what is it specifically, stripped down to its bare, concept? What is it about environmental rule of law that kind of makes it peculiar in this day and age? I mean, if it wasn't necessary, say 5-10 years ago, why do we need it now? So I guess in short, what's special about it at this point? What gives it currency in the current world we're living in?
Thank you, Bruce, for the question. So, in my view, it should have been emerged like even a long time ago, not just nowadays. But what is so what's the why is it raised this time, and what's the benefit of it? It's because I think now the society has become more complicated, and the implementation of any laws, not just environmental laws and human rights laws, I think that requires more of a strong governance. So strong environmental governance that is working for people or with people, and so that will I think that is the recognition of the reality that we are living in. So it's not going to be just one government or one part of the government being able to actually work on the improvement on environmental degradation. And two is so that requires that, and also like sustainable development goals. So also that is also that is something also states are and the UNEP and everybody is working on. So for that also the environmental rule of law concept is really, really important to make sure that there are like 16 goals, and goal 16 is about strong institutions and justice, but not just that, but we have goals on environment such as biodiversity and climate action and water and energy. All this requires environmental rule of concept to be embedded, in my view, and as strong institutions and justice. So I think one is the complex society that we live in. It's not going to be done by one ministry or one person, and two, also to support the sustainable development goals, achievement of that.
Thank you so much. I hear you to be saying that. So environmental rule of law, it's kind of like the thread running through all forms of governance and decision making, and you can't have any form of proper and effective environmental governance without environmental rule of law being the bedrock of such decision making. Thank you for a wonderful presentation. I see we have a few questions, one for now in the chat box, but I'm going to defer that question up until the end. For now, I'm going to call upon Professor Tumai Murombo to come and speak to us about some of the practical aspects of environmental rule of law as it pertains to civic engagement. Professor Murombo, the floor is yours.
Thank you, Bruce, and thank you, Su Yang, for that interesting presentation. Thank you, participants, for taking the time to join us on this session. So I'm just really trying to share my presentation. Okay, Bruce, are you seeing the presentation or the slides themselves?
Yes, Prof, we can see the presentation.
Okay, thank you so much. So I'm going to talk about civic engagement and environmental rule of law. In particular, I'm interested in looking at only one of the 4 aspects of the global environmental rule of law reporting program that Su Yang made a reference to. By way of outline, I'm going to try to connect to some of the issues and some of the aspects that Su Yang made reference to in her presentation, so that you can see and appreciate why civic engagement is important and a precondition for effective civic engagement or involvement of members of the public and local communities in environmental decision making. That is sort of a rough definition of civic engagement, but there are many formal definitions of what civic engagement is. But when it comes down to the basics, it essentially refers to the involvement of members of the public in governance processes and decision-making processes. I'll go into detail about that in a minute. Then I'll also look at forms of civic engagement used by environmental advocates groups, environmental activists, resource governance, lobbyists, and activists, as well as community groups. And the third part of my presentation will focus on a discussion of public participation and try to put it within the context of civic engagement, which by definition is much broader than simple public participation. Fourth, I will then look at in detail at what are the required conditions, what environment is necessary for there to be effective civic engagement and the exercise of the rights to participate in environmental decision making. And lastly, I will explore briefly the concept of protest as a form of civic engagement and the implications of deploying that tool, particularly in repressive regimes. So, reflecting on what has already been said, civic engagement, as it were, fits well within the conception of the rule of law and the concept that the rule of law itself does not exist on its own, or it cannot subsist on its own without certain fundamental pillars of democracy being in place. So as far as I could find out, and as far as I know, the rule of law as a concept is really an issue of governance. It assumes and presumes good governance in any country, in any state, or in any global community. And good governance here is conceived of in a much broader context than just political governance. I am particularly, and we should be particularly interested in good environmental or natural resource governance. Oftentimes, when people are talking about governance, we rush to think about political governance. We run to think about politics. But good governance also has got various other dimensions that are apolitical, in the sense that they are focused on how resources or how sectors are governed and what rules are there to enable inclusivity in the governance process. And the elements of democratic resource governance include the rule of law, but also other institutions, other procedures, other rights that must be in place for effective civic engagement to take place. And this also implies that there are many forms of engagement. You can see I've removed the prefix civic, because civic engagement is just one aspect of engagement, but there are other forms of engagement, wherein the government or administrators, public administrators, regulators, law and policymakers get the public or stakeholders involved in their processes and decision making. And this involves involvement not only of civil society, but the public in general in the process of governing. Most democratic states, therefore, start with representation as a form of engagement or civic involvement. So the very fact of constituting a government, whether in terms of a constitution, whether in terms of traditions, if there are no written constitutions, like in the United Kingdom, for example, you notice that the question of democratic participation begins at the constitution of government, at the constitution of institutions of government, in particular, the legislative assemblies or the parliaments. That is the initial point, the fundamental entry point for the public or the citizens of a country to participate in the governance process of a country. So once we choose or we elect representatives, we have already begun the process of being engaged and being involved in law and policy making, because in most democratic dispensations, it is the parliament, it is the elected representatives that are responsible for making laws and policies, for changing them if it is necessary, for changing them in reaction to or in response to feedback and input, criticism, or compliments from members of the public or the civic community. Therefore, the process of electoral democracy is very critical for civic engagement. We can get it right there, we can get it wrong there. But it is not a given that once you elect your legislative representatives, your rights, your interests, and the environment indeed will be effectively represented. As we know, in most democracies, there are political parties with vested interests, with ideologies, with certain persuasions, even including ideologies in relation to environmental matters, to natural resource governance, climate change, gender, the youth, and all sorts of issues that are relevant to government. So once your elected representatives are now in power, it is not always the case that they represent the interests of their constituencies. And in this case, it is not always the case that parliamentarians or legislative assemblies are there to advance the resource governance and environmental interests of constituencies. It is therefore important that beyond parliamentary representation, we look at what are the other forms of engaging the governance process. So when you look at this, I've already looked at some of the political aspects of representation. But one thing for certain is that whether or not there is effective civic engagement in any country depends a lot on various factors, on various dimensions of government and constituting a government. Part of this is the law and institutions that Suyang made reference to. And also part of this is the question of rights, which you may find in a constitution of a country, or you may not find them in some countries' constitutions. So the political history, the culture, the traditions, the human rights, ethics, attitudes, and culture of a country, and its current political dispensation, as well as the power dynamics that the political dispensation shapes and give rise to, are decisive in terms of shaping the landscapes for civic engagement and the spaces and platforms that are available for members of the public and civic society to get involved in shaping laws and policies that relate to natural resources or to the environment. This landscape includes not only the political landscapes or the laws and institutions, but it also actually goes to solve the economic aspects of a particular country, the gender issue, your cultural dispensation, cultural and history, the role of women and the youth in your, all these aspects, they shape the landscape for civic engagement. Whether or not you are a developing country, you are a developed country, availability of resources, funds to mobilize, to participate. There's a cost to participation, basically. That is what the economic aspect refers to there. The social aspect refers to, among other things, gender, marginalization, exclusions, and other forms that create hierarchies and power dynamics in a community or in a country. These things or these factors do shape the form that civic engagement will take in any given country. For that reason, it is quite difficult to prescribe any particular formulas or tools that would definitely work universally as a form of promoting civic engagement. So context does matter, but context must not also be used to further marginalize and exclude citizens and members of local communities from participating in environmental decision making. And in terms of the forms that civic engagement can take, it can be formal. So you do have your invited spaces where, whether it's a ministry, another government department or an independent regulatory authority, or whether it's a municipality, a local government, where, or even a private company, where they invite members of the public either to comment, to submit objections, to submit suggestions on a policy that is being developed, on a program that is being rolled out, on a strategy, on a plan that is being developed or being proposed. Not often formal spaces of engagement are targeted. So they are very narrow, focusing on a specific aspect, on a specific issue, a specific plan, policy, or a law. And often, because they are formal, they tend to degenerate into what we call a tokenistic approach or a formalistic approach. Tokenism really is just another way of saying it's a formalistic approach, a routine approach. So there is often a tendency for formal spaces of engagement not to be meaningful. There's a tendency for formal spaces of engagement to be exclusionary, both procedurally and both substantively, in terms of what exactly can you say, and to what extent can your contributions be considered by the decision maker, the policy maker, or the lawmaker. That leads to a democratic deficit, the constraints of formal spaces of civic engagement. And this deficit in terms of the openness or the accessibility of decision-making in formal spaces, civil society and members of the public have come up with their own creative and innovative ways of creating informal spaces for engagement. This could be through activism, and the idea could be really be motivated by the need to change the way decisions are made in relation to natural resources and the environment. Often there is the perception, reasonably, that some decisions are predetermined. They are made in cabinets, they are made in parliament, they are made in the executive by ministers, they are made by regulatory institutions and agencies, and they are brought to the public for consultation or for comment. Yet it could be more meaningful to involve the public and to engage with the public even before you have any draft policy, law, or decision. So you come to the public with a zero draft. And when you, whether you're looking at formal or informal forms of engagement or spaces or platforms where you can engage, the whole idea of engagement is much broader than simple public participation, as I've noted before. So when you look at some of the examples of these platforms, to just give you an idea of why I'm saying civic engagement is much broader than mere public participation. I've already spoken about choosing leaders, but choosing leaders can be the political process. There's also the process of choosing leaders and the appointment of technocrats. There must be avenues and platforms for members of the public to comment on the expertise, on aspirants that are going to be appointed for positions, whether they are professional positions, whether they are political, technocratic positions. It is important for members of the public to be involved, particularly if the authorities being appointed are responsible for managing or for dealing with natural resources that affect the public, or if their activities have the potential to cause significant damage or injury to the environment or to the health of the public. So this includes from law, policy making, development of strategies, frameworks, integrated development plans, local development plans, municipal bylaws, your rules and regulations, the issuing of permits, your water permits, mining authorizations, hunting permits, development permits, and environmental impact assessment processes. All these are platforms through which members of the public may be engaged or may be involved in the process that eventually leads to decisions that affect use, access, or impacts on the environment. So you can see that there are two dimensions to the process of engagement, whether it is formal or informal. There is the procedural aspect as well as the substantive aspect. The influencing of a process and aiming for a substantive outcome including potentially vindicating or enforcing rights, includes both process issues and also outcome issues, what I'm referring to as the substantive part of civic engagement. But often, your substantive outcomes are as critical as the process design itself. So sometimes the effectiveness of civic engagement tools, processes, and platforms is hinged upon or is anchored upon the process and how the process itself is designed. That, for example, refers to what I noted is tokenism or formalism, what has become the routine process of developing a policy, developing a law, or developing a decision position and bringing it to the public and saying, please, can you comment? When you know very well that the decision is already cast in stone and there may be no ways for members of the public to hold the decision makers accountable on their decision, whether through a review process or through asking for reasons for the decision or other administrative due processes that may be available in any given country. And just focusing on public participation as one form of civic engagement, because I think it is possibly one of the most favored forms of civic engagement. What are the benefits of public participation? So this is routine, and I'm assuming that we have a broader audience in the participants. So forgive me if you are a specialist or an expert in public participation, but I think it's important for us to now and again reflect on what are the potential benefits of public participation or civic participation. It has the potential, a very likelihood, high likelihood to lead to informed environmental decision-making processes and decisions. It builds trust and solidarity between those who are entrusted with managing natural resources and controlling impacts on natural resources, for example, pollution, and building trust with them, between them and members of the public, and solidarity. It is also a learning process, because once you go through the process of obtaining information and being informed and engaging on that information, unpacking, dissecting a policy, dissecting a law, a plan, dissecting an ERA report, and then allowing the decision maker to make the decision. The public also learns through the process. The more you get involved, the more you participate, the better you become at appreciating the consequences of decisions, the significance of impacts of activities on the environment, the significance of certain decisions in the near term and in the long term in terms of sustainability. Also, the process of participation is important because once you build the trust, the solidarity, and there's been a learning process, the members of the public get emboldened and get a solid foundation to be able to hold the executive and decision makers and agencies responsible for implementing decisions accountable. It is difficult to hold the government, regulators, and agencies accountable if you are uninformed about how a decision was arrived at, what factors were considered, what documents, what reports were considered, what inputs were considered before a decision was taken, which is the whole really gamut of participation. If you don't have that package, it becomes very difficult for a member of the public or a citizen to hold the executive or the government accountable, because you need the information, you need the tools relating to the process in order to promote accountability. And while it's on that point, it means that transparency is very important. There can be no trust and solidarity without transparency in decision-making, transparency in sharing information on the basis of which a law, a policy, or a regulation is made, or a decision to go with route A instead of route B is made. But these benefits are obviously subject to certain preconditions. And this is what I want to go to now. We will not be able to have effective informed participation unless we really have an environment in which the three pillars of participation or engagement as laid out in the Aarhus Convention on Public Participation are really present or exist. And these three pillars are public participation itself, or a framework for participation, access to information, as well as access to justice or access to remedies, as it were. You can also see that this aligns very well with some of the components of the environmental rule of law that Suyang presented on in a presentation. So, talking about these prerequisites for effective civic involvement, I'm just going to highlight there are other issues we can discuss. We can go deeper as far as these prerequisites are concerned. We can look at some of the variations that you see depending on the political dispensation in any given state, which I have made reference to already. But one key prerequisite for effective civic involvement in environmental governance is firstly the recognition by administrators, by governments, by regulatory agencies, the recognition and the valuing of public or civic contribution. That is the first step if you are going to be building a strong ethic or a strong tradition or practice of civic engagement. There must upfront be a recognition, acknowledgement, and a tendency, or rather a culture of valuing the input of the public, looking at the public as entities, as individuals, as communities who have something to put on the table. That is the first step. You can make nice laws, provide very open platforms, as long as the government, the administrators, the politicians, the technocrats do not really genuinely recognize you and value your input, then whatever you're going to contribute may not really influence the outcome. Then once there's that recognition, acknowledgement, and evaluation, it is important for the state to create meaningful and underline meaningful substantive platforms. These must go beyond consultation or the now popular notice and comment procedures. By meaningful, we're talking of platforms that enable communities to learn, access to information, access to knowledge, and the process of also decoding expert, scientific, coded information that is often used by technocrats when they are making decisions, whether it's in relation to a law, a policy, an EIA, a permit, or whatever. You will find that there's language involved, there's coding that is involved. So meaningful participation presupposes the availability of platforms and processes and tools to learn and to decode information and to then use it once you have been able to understand it in a substantive manner to influence outcomes. So because of this process, presuming or assuming that the members of the public or communities become part of the process, there is a gradual shift in modern times to what one might call cooperative or co-creation or co-governance. You will find the terms are used interchangeably in various sources. The whole idea is that decision makers, law and policy makers take members of the public, take civil society into confidence, and they make them part and parcel of the process of creating, whether it is a policy, a law, or creating the fundamentals of a decision. So it means that this is democracy really par excellence, when we have shifted to a level where there's co-creation, co-governance, and members of the public, citizens and regulators can co-own a decision, a law, or a policy. There's long-term impact that arises from these preconditions. And these long-term impacts are aligned to the outcomes, to the expected impacts of sustainability and sustainable development and sustainable use of natural resources. And they also enable the executive to be held accountable, because if the process is open, if there's involvement which approximates co-governing, it becomes quite easy for members of the public to approach the executive directly through appeals or review processes, or to again take up decisions that you are not happy with through litigation, public interest litigation that is aimed at influencing those decisions. So the judiciary is very, very important. I didn't list it here specifically, but As a fifth prerequisite factor, you need an effective judiciary that can assist not only the members of the public, but also the executive and parliament or the legislative arm of the government to interpret and to understand the laws that they would have made. It is quite funny that you can have parliament making laws that they do not understand or that are vague, ambiguous, and are difficult to interpret and to apply in practice for the executive as the implementers of laws. So the judiciary is quite critical when it comes to environmental governance. And it is important that as we are talking about enhancing the environmental rule of law, the justice component that was referred to by the first presenter extends to building the capacity of the judiciary as the protectors, the interpreters of the law. And in that process, they influence not only what is the meaning or the conception of law, but they also can influence what laws parliament can make. The judiciary is also the guardians of the constitutions and the rights in the constitutions, including your environmental rights. In that process, they can also enable and play a very effective role in ensuring that civic engagement is effective and delivers on the outcomes that are expected. And obviously, you need a strong judiciary in order for you to hold the executives accountable, to challenge decisions that are not proper, that are not reasonable, justifiable, and not cannot be substantiated on the facts and inputs and contributions from members of the public. So despite really all of us having this knowledge of what are the prerequisites for effective civic engagement, we still have a lot of challenges. As I was talking already, I've made reference to some of these challenges, but I'm just highlighting some of the major challenges to effective civic engagement. The question of political control, which continues to marginalize vulnerable groups, remains a big challenge to open, inclusive, environmental decision-making. By political control, I'm referring here to the self-acclaimed right of politicians, the ones that we elect and those that are appointed, to assume that they are not our servants, even though they are civil servants or public servants. There is this perception in many jurisdictions where they believe that we are actually beholden to them and their voices are louder than ours, they are more reasonable than members of the public. We still have that problem. Although, of course, in some jurisdictions, this problem presents itself in a much lighter mode compared to other jurisdictions, depending on how democratic a political dispensation in any country is. Then, obviously, we still have the challenges of the power dynamics that are not only linked to the political control, but they go beyond that. They go towards social power, they go towards economic power, and the ability to influence environmental decisions. This is where you find the differentiation between the power and the ability of private corporations to influence policy and decisions, juxtaposed to the power and influence of ordinary members of the community or the public. So these power dynamics, we still need to deal with them in terms of how we design the process of civic engagement, how we design the laws. That is where we have to deal with these power dynamics, to neutralize them, to shift power, and to create spaces where those that are disempowered can feel empowered and feel confident to influence law, policy, and environmental decisions. But currently, we remain with challenges as far as technocrats and experts are concerned, because there is a tendency for us to really just bow down to evidence-based decision-making, scientific expertise. But I mean, as the pandemic has demonstrated, science is not infallible. There are other ways of knowing and knowledge creation, other epistemologies that are important for influencing, particularly the use of natural resources and access to natural resources. And one could go further on this point to point out the marginalization of traditional and indigenous knowledge systems when it comes to making decisions that are now increasingly being marginalized by the formal law, the common laws, legislation, and the indigenous, the customary has really fallen into the background, as it were. Yet it remains quite important to promote sustainable livelihoods, sustainable decision making when it comes to natural resources. And even in democracies, there is a lot of literature, some of which I've referred to on the website and in the reading list at the end, that the spaces within which a civic society or communities or the members of the public can get involved are shrinking. One interesting report that I made reference to points out that this may be true, but it also challenges that narrative by arguing that what could be happening is really a shift in the power dynamics that I've referred to here. So there are the other perspectives that argue that instead of really civic space shrinking, it is changing. It is like tectonic plates that are shifting as opposed to shrinkage of space. But again, that argument is premised on what I've already pointed out as the determinants of whether or not you are going to have effective civic engagement. That is your political dispensation, your traditions, your political culture. That might determine whether or not your space is shrinking, expanding, or flattening out. But another critical issue that is coming up.
Prof, if
Yes.
I may, can I just ask you to wrap up in 2 minutes? I think we're almost running out of time.
Sure, we'll do that. So I was saying that against this context, there are also now claims of what you might want to call participation fatigue, particularly from the regulators. And this is one of the conclusions from one of the sources, that, you know what, yes, engagement is good, public participation is good, but how far should we go in allowing the public to participate and to influence decision-making before we behave plebiscites and referendums on each and every decision? So while it is good to involve members of the public and to promote a civic engagement, it leads to all these benefits that I have pointed out and that have been summarized in this quotation here. But an important aspect is what is said here in the end here, that it can make it harder for decision makers to choose between options and inevitably lead to delays in the provision of services, because decisions get challenged, there are appeals, there are reviews, and there are appeals on appeals. It is essentially because it becomes quite difficult when you have too much information in front of you as a decision maker. Then lastly, I want to talk about protest as a form of civic engagement. This has been contentious, particularly in the last 5 to 10 years, which know the hashtag movements, the council movement, and the culture of holding the executives and authorities accountable outside their comfort zones. So protest is quite good, but only when formal and informal platforms and spaces begin to shrink and fail, it becomes necessary to protest sometimes. Protest disrupts the status quo. It attracts the decision makers' attention very quickly, as opposed to writing a letter, writing an email, blogging, or following an invited space. But this has to happen within the confines of the rule of law that we're talking about here, and respect for human rights of those that may not be participating in a protest. Otherwise, there's a risk of delegitimizing legitimate and valid claims that are being protested about. The downside of protesting, if you are not in a democratic dispensation, is that it can also really result in the backlash from repression and repressive regimes. And where you can Google in your own time and read about the risk to environmental defenders and human rights defenders of protest actions. But always protest becomes necessary if everything is moving too slowly and we need action now. For example, the current drive towards enabling climate action. So these are just posters to demonstrate why protest sometimes becomes necessary if formal and informal spaces for civic engagement fail to deliver on the outcomes that we expect. Then in conclusion, I think that natural resource governance and making decisions relating to the environment are sites of contestation. There are conflicts that are bound to arise. in relation to the powers, the rights that are involved there. Therefore, multiple tools are important in terms of trying to get involved. No one tool is a silver bullet to get your point across. But the early involvement is very critical. So jump into the playground very early before the decisions are made, before avenues are foreclosed, because that could result in litigation becomes necessary, increasing costs and delaying decisions as well. There's a strength in numbers, obviously. So social and civic mobilization is important. Genuine mobilization, not where you are just trying to use issues of a constituency to advance other agendas. So genuine civic and social mobilization is quite critical for civic engagement. And engagement must be constructive, even if you are dealing with adversaries, let's say government, for example, of private corporations. There's nothing wrong in engaging with the government, in engaging with private corporations, as long as there's a caveat that you reserve your right to litigate and to take them and hold them accountable if the engagement does not yield the desired outcome. Because confrontation on its own and for its own sake sometimes does lead to poor outcomes. Conflict, you destroy trust in this alienation, and often your point is ignored with little consequences. So please remain engaged. Thank you.
Oh, thank you so much, Prof. Morombo, for such an insightful presentation. I guess the one takeaway we can take out of this is that ultimately civic engagement is environmental rule of law in action on both levels, that is at the governance level and at the citizen level. So in other words, there cannot be effective environmental rule of law without both parties playing their part. I was interested in what you mentioned close to the end there about the council culture. How I wish the council culture worked with governance, how I wish it worked with people in politics, then maybe our world would be so much better. We've had a few questions, and I'll just start with two that are directed at Sue, but I think, Prof, you can also come in there and chime in.
Bruce, would we just quickly ask Tamai to close his screen sharing so we can see you all a little better?
Right, yes.
Prof, I'm trying to get my controls, I can't find them.
Angela, are you in a position to assist there? Prof, if you can perhaps hover your mouse towards maybe the corners of the screen.
Okay, I've surrendered control.
Thanks.
Okay, Angela, are you in charge of my screen now?
I am trying to be in charge of your screen, but I cannot close your screen.
Can you hold on? Can you hold on? Let me try to do something.
Sure.
Can you go at the way it says Angela Sintena or mic controlling at the top there? The orange.
Okay,
no, I don't think we can see it.
For time's sake, maybe we should start questions, and if to my manage.
I think you can start. Angela, can you hand back the control? I'll try to deal with this.
Yep, I'm doing that now. And Bruce, back to you.
Thank you very much. Technology at its best. So one of the first questions was given, it's assuming that the global rule of law is not implemented or disregarded by a country, would there be sanction to that effect? I suppose the question is asking, how can we make sure that the state is held accountable, citizen action, would that be possible? Sue? Dr. Wang?
Okay, thank you. Thanks for the question. And yes, so the question is, so environment, I think it always comes down to implementation and what to do when it's not implemented. So one is, so I think strengthening the compliance. So environmental rule of law itself is not something that we can implement. We can oblige states to have legal obligations because it's not environmental law, or it doesn't really impose a legal obligation. But so this the environmental rule of law concerns all the NEAs in multilateral environmental multilateral environmental agreements, also human rights treaties, which specifies a state's obligations. So what we can do is it's not so much of a sanction coming from environmental rule of law, but imports or encourage states to comply with the environmental obligations under MEAs and also under environmental human rights laws. So it is to strengthen the compliance mechanism, especially what I have learned from in the past few years, since I come from the human rights background and on the environmental area, is the compliance mechanism in environmental law is pretty weak in many ways, and monitoring and also enforcement. And that what human rights framework can help is actually reinforce that. Because you can, you've seen somebody mentioned about litigation, and there's a climate litigation and everything, and they're using human rights obligations in that. So what can we do is to increase a level of compliance with the multilateral environmental agreements, and also creatively using other frameworks such as the human rights framework and the human rights obligations in the implementation. So that would be my answer to that. And Bruce, can I just go back to your first question about why it is why are we talking about environmental rule of law now? Is I just wanted to add to my answer that environmental law is as the first global report on the environmental rule of law said, we've observed like 38 times a fold of increase in environmental law since the 1970s. So we have enough laws, and it's not, but then the world has not gotten better. It's actually we have more and more environmental crisis. And so it's not just about having the laws, because having the law doesn't really make huge difference, although it's important. And now is what's really important is the implementation, and the laws are not implemented in the vacuum. So that's why we need a concept of good governance and civic engagement and the rights issues and justice. So that's what I just sort of wanted to add. And also when you see, when I said the coherence, it's about environmental law. You can enforce environmental law and very strict about it, but sometimes that works against human rights law. So we've seen a lot of cases of such as conservation efforts, and sometimes it kind of resulted in the eviction of indigenous peoples, which violates the indigenous people's right. So that you cannot have one law that says one thing and violates the other. So we are trying to converge all these two and make sure that nothing is violated and nothing is contradicting each other through this concept of environmental law. And sorry for this long answer to your question, and I hope I answered the question. Thank you.
Oh, fantastic. Thank you so much. I would say in the silliest example I can give, if sustainability was a destination, then environmental rule of law is the vehicle we need to get there. Professor Tumai, I think I'll direct the second question to you. Is environmental justice also part of rule of environmental law? How does it picture in climate change regime? I think this feeds into the whole aspect of civic engagement and civic participation as a form of also trying to advance environmental justice, as we are seeing in climate change regime. Do you perhaps have a word on that?
Thanks, Bruce. Definitely, environmental justice is, if we had the whole day, we would have gone in detail in some of the concepts and the issues that we were discussing here. But you recall that I made reference to the three pillars of participation and engagement, one of which is access to justice. Justice is much broader, beyond access to the courts and beyond equal protection of the law. Environmental justice is very critical, and it is actually quite critical at this juncture in this age when we are looking at public interest litigation, which is also obviously, as Lisa has pointed out there, a form of civic engagement, both invited and also uninvited, obviously. But when you look at what is currently happening, particularly in the space of climate change litigation, and if you link that to the question of the transition from our current modes of producing and consuming energy and the impacts on the environment, particularly climate change, climate justice and just transition cannot be understood outside the foundations of environmental justice. So EJ is very, very important. It is foundational to most of the theory that we are trying to build and the tools we are trying to build to promote a just transition and to address the question of climate change. Thank you.
Thank you very much. I have two questions that I have for you guys, but I just want to ask Dina, are you going to say something about the Jamboard?
I can. Should I do that now or?
Right at the end. Let me just ask these two brief questions to the panelists. So my questions are very, very basic, right? But let's just assume that we have in the midst of this presentation people that are like, and I mean this in the kindest way, maybe lay people that are not well versed in the law. Sue, what would you tell them about environmental rule of law? Explain it to the basic terms, to the normal citizen out there. What are you going to tell them about what they need to do about environmental rule of law? And Prof. Morombo as well, about civic engagement. Talk to that old lady that is at the farm, that is, in an indigenous community. What can you tell them about civil society and what they should do? Should I start with Prof?
Thanks, Bruce. So I think in terms of civic engagement, if you want to decode it and put it in the plainest of language that an ordinary man in the bus or in the street would understand, we go back to the basics. It's government of the people, by the people, for the people. So be involved. And the idea is to really fight against apathy and fight against the growing pessimism with the ability of government to govern and to listen to the ordinary people and ordinary citizens. So because electoral democracy is facing quite difficult challenges in different environments, I think civic engagement is about getting involved and taking part in decisions that impact your life and that impact the space around you.
Thank you, Prof. Dr. Wang?
Thank you, Bruce. Sorry, I actually cut up for a bit when you're asking the question. So I think the question is, how would I explain environmental rule of law to a person who is not too familiar with this concept? Is that correct?
Yeah, like a layperson in its simplest forms.
Okay, yeah. So I would say this is a very basic question, but I don't think it's a basic answer to that. But I would say we're taking a very holistic approach to this. So we're just not looking at environment and humans and sectors of the government or those. So I think everything has to come together to make sure that we live in a planet that is healthy and that also like everybody, like not just people living in a healthy, environmentally healthy areas are happy, but so everyone actually having been able to enjoy their right to live in a healthy environment. So I would say it's everything about that we experience on a daily basis, but also I want to emphasize on the solidarity on the environmental rule of law and also environmental and human rights issues, because we're all connected within the environment. We're connected to environment. We're also connected to what I do affect others and what others do affect me. So I think it's really about, the connectivity and the solidarity.
Thank you, thank you. So I suppose the greatest message, at least what I get out of this whole presentation, is that we're more powerful when we're in numbers. I mean, if we're going against the state and its decisions, if we're going against companies and their decision-making, our voices are louder when we gather together, whether in civil societies or whether it's community groups, in challenging those decisions or in participating to have a greater say in what ultimately impacts our daily lives. Thank you so much to the speakers for the presentations. I'll hand over to Dina, who will say something about the Jamboard.
Thanks, Bruce. Thanks to the presenters and thanks to everyone for your contributions to the Jamboard. Just to tell everyone that we're gonna keep these resources and we're gonna make them available online so people can come back and have a look at them afterwards and and keep using them and thinking about them. So the Jamboard asked 5 questions, I think, and I'm going to go through them very quickly in the last couple of minutes. The first question: how can environmental rule of law help build back better after the pandemic? People commented about the importance of improving the quality of life through the environmental law, through creating enforceable mechanisms and concepts, through developing resilience and focusing on improved participation in decision making, greater state and bureaucratic buy-in to environmental and health governance issues, and using the tools of law to secure healthy environments. The second question asked, what kind of key changes can you expect when the right to a healthy environment is recognized by the UN? Some of the answers that we saw were shifts from the international to the national level, so shifts in national legislation, better regulation of private enterprise, more international funding and support for domestic environmental programs, more pressure on state parties to implement and enforce rights, less marginalization of vulnerable groups who have another tool with which to fight, and then a cynical voice in green: not much will change. This voice says we need the political will. The next question: what are the 2 most prominent obstacles to civic engagement or public participation in environmental matters in your jurisdiction? And there are lots of interesting answers to this question. Too much focus on other issues, someone writes. Ignorance, a lack of rules and regulation, a lack of public enlightenment, problems with resources, cynical attempts by developers and government to undermine community participation, threats to environmental activists. Those of you who are able to join the session we had yesterday on environmental defenders, that was a big focus there. Failing to make information accessible in languages and forms that the affected community uses. So the next question asks, how can civil society play a role to promote civic participation by disempowered communities? People have said they can advocate and support their participation. They can create awareness through awareness building movements and provide access to information. They can secure education. They can mobilize resources, including cell phones, laptops, data, funds for travel. This is all incredibly important in times of pandemic as well. They can support the protest. They can help secure accountability. Those are some great answers. The next question turns to the pandemic. How has COVID affected civic engagement in your country? Someone writes that bills have been passed without consultation. I think we've been seeing that all over the world. Sorry, did someone want to say something? Yep. People have not been able to gather or network, and not everybody can access internet resources and Zoom. Fear of loss of jobs, making people more focused on their own private circumstances than on kind of public interest issues. Problems of access to internet, tighter restrictions, lockdowns, curfews. These have all really hampered participation and civic engagement. And then the question is, what are 2 things that can help implement environmental and human rights law? Strong institutions in the enforcement of laws and monitoring, good governance and good implementation. This connects to what Suyang was saying at the end, is that we're increasingly seeing good laws, and it's now really important to turn our attention to the importance of implementation and well-resourced and supported communities. And that's it from the Jamboard. Thank you again to everyone who made a note on the Jamboard. I think it's an incredibly diverse and useful resource, and it'll be online for anyone who wants to have a look at it. It's also going to remain there for a few hours today, so if you want to go back to it and add a sticky note, go ahead and do that. Thank you, Bruce.
Thank you, Dina. Once again, thank you everyone for joining us for this session. Just a reminder to those that we can join, we're going to have another exciting presentation in the afternoon on decolonization and protected areas. So you're more than welcome to join us there as well. Thank you, Professor Tomai Mrombo. Thank you, Dr. Suyang Wang. Thank you, Dina. Thank you, Angela. Have a good day and stay safe.
Thank you, facilitator, for a good job.
Thank you.
I'll be sending the bill.